So at the moment, only certain properties have to be licensed. So you can have lots of HMOs, and we do have lots of HMOs, but not all HMOs need licensing. So there are some particular properties which are called mandatory licensable HMOs that the government has decreed must be licensed across all of England and Wales. And at the moment, that is HMOs with 5 or more occupiers which comprise of 3 or more stories. Now the short form answer to this is after October 2018, the stories question goes away and any HMO with 5 or more occupiers needs licensing. So there were kind of problems in the previous definition. In theory, you could have a bungalow with 10 people in it, which didn't need a license. So we're getting rid of that situation. But there's a slightly different set of rules depending on whether it's a house or a flat and the nature of the flat, so it gets a bit more complicated. So if you have a house that has 5 or more occupiers in it, you need a license. End of discussion. Whether it's 1 story, 2 stories, 3 stories, or 10 stories. If you've got 5 or more occupiers in your house, and they're sharing basic amenities, so it's an HMO, it's going to need a license. If you have a self-contained flat, then it depends on the nature of the flat. So if your self-contained flat was created by conversion from a single larger dwelling, so for example a large house turned into 3 flats, then if you've got 5 or more occupiers in any one of those flats, then that flat will need a license. If, however, your flat was created by being purpose-built, so someone turned around and said, I am going to build a block of flats, and your flat is one of those, even if it's got 5 or more people in it, it will not need a license, except if it's in a block of flats which has only 2 flats in it. Now, I'm not convinced that there are that many blocks of flats with only 2 flats in, but a more common example, of course, is a shop with 2 flats above. So if I was to build a shop with 2 flats above and it's purpose-built that way, then if one of those flats had 5 or more people in it, that would need a license. So there's a limited number of purpose-built flats that are going to need licensing. There'll be an awful lot of flats, potentially, larger flats, of course, which are created by conversion, which might need licensing. And of course, for a lot of people, there's going to be a lot more houses that need licensing. And for some local authorities, they're going from, some local authorities, it's much of a muchness. They've got quite a lot of licensable HMOs already, and they'll have a few more. Some local authorities are going from basically nothing needing licensing or having like 20 licenses to having to deal with hundreds of licenses because they don't have very many 3-story properties, and they've suddenly got to cover all of the 2-story properties as well. Some landlords are going to be caught out. Some landlords were thinking, be all right, I'll just buy 2-story property. That deal's gone away. So the way to evade this now will be to have 4 people in your property, and I'm sure some landlords will do that, but of course you're then sacrificing a degree of income, and you'll have to consider whether the financial balance is worth it. And there is a tight financial balance here between the license fee potentially and the amount of rent you're going to receive, and I'm sure it will be different for different people. But in principle, it's about getting more properties licensed that are known to be risky. The fact is that the government is well aware that certain properties do sit just below licensing thresholds, and they do tend to be slightly poorer quality. So it's about widening that threshold and bringing more properties into licensing. Obviously, where a local authority has an additional licensing scheme, some of it will get stomped over by this, and people who have additional licenses under that additional license scheme will still have licenses under the new regime, so they get grandfathered across because an HMO license is an HMO license. If a local authority has a selective licensing scheme in place and you're licensed on the selective license, then provided your property was an HMO before October, you will automatically get a mandatory HMO license. If your property was selectively licensed but was not an HMO, then you will have to apply for an HMO license if you want to make it into an HMO. So there are some grandfathering options for pre-licensed property. The last thing that's really important to be aware of is just because my property's already let out to 5 people before October, that doesn't mean I'm exempt from licensing. So October licensing sits across the whole sweep of all landlords, and if you don't have a license on the 1st of October, you're liable for prosecution, you're liable for your tenants seeking a rent repayment order to make you pay back the rent that you've collected since the 1st of October, and you will not be able to serve a Section 21 notice. So it's really important to make sure you get applications in before the 1st of October.